the committee has come to a decision with regards to the arguments that were heard this morning. Just before that decision is announced, I did give some legal advice to the committee to assist them during their deliberations. I'm announcing that now, and the advice that I gave, just so it is in the public forum and everybody is aware of what I said. I read to them Section 17 of the Licensing Act of 2003, which Mr Evans referenced during the course of his submissions. I also read again Regulation 10 of the Licensing Act 2003, premises licences and club premises certificates regulations of 2005. Similarly, I read Regulation 5 of that same act to them to refresh them of the arguments that were made surrounding those regulations. Mr Evans also quite rightly outlined the legal test that's to be applied, and the way that I framed it to the committee is as follows: questions to be answered. Firstly, is there a defect in either the application form as announced or the blue notice as stated by Mr Evans? Defect a breach of any of the regulations that are did. And thirdly, is there substantial compliance with the regulatory regime overall, or has any prejudice been caused to any parties concerned as a consequence of any breaches of those regulations if they are so found? I also read a section, which I will also read, of Section 182 guidance, which has been issued by the state in these matters, paragraph 8-26. It states the following: the government recommends, as for written applications, that electronic applications should not be returned if they contain obvious and minor errors, such as typing mistakes or small errors that can be rectified with information already in the authority's possession. However, if this is not the case and required information is missing or incorrect, the licensing authority may hold the application until the applicant has supplied all of the required information. That's all the legal advice that I gave to the committee during their deliberations, and I'll hand over to the chair to announce their decision.
Thank you very much. We have taken considerable time to discuss issues that have been raised this morning, and we are all three in agreement with our decision. We find there is a defect in the form as far as the signatures were concerned. They were missing, and this is a contravention of the Licensing Act 2003 and the club premises of 2005, and we acknowledge that. The reason we consider the word shall to be mandatory, and the names of all of the people should have been listed on the application form. We as a committee, despite the contravention, there is no caused to any part. And reasons for that, we feel, are that the vineyard has been in operation since 2018. The residents would have known who the partners in the partnership were, in the business were. Word was discussed around the village, it appears, because there's been all of these people saying that they weren't happy with it. So it must have been known around Pattingham, etc. It is a family-run business, and residents of the community would have been aware. Emails going around that people must have seen. We significantly feel the number of objections that have been received are not substantial. Well, if you will see, the person's name, Stephanie Wilcox, was mentioned. Her name was on the form, although not in the partnerships. Really, the notice, we do accept that the blue notice could have been read from where it was positioned. We do find a defect in one notice sign, that it should be every 50 metres, and there should have been one sign, but that did not prevent it from being where it was actually positioned. We do not feel that any prejudice to any parties have made any difference to what has happened in this case. And we feel that it should continue. This should continue.
So the committee have given their decision on the points raised. We can move to the second part now, and submissions can be heard on whether or not the licensing objective hand over to Mr. Evans to make his submissions.
I just wonder whether or not, in the normal process, the applicant would go first.
Yes, no, you're absolutely right. Apologies, Mr. Semper first.
In the order of batting that was sent out, yes, but if you'd like me to go first, Chair, clearly.
Yes.
Okay, good afternoon, members of the committee. My name is Nick Semper. I'm a licensing consultant. I'm representing Passingham Vineyard in their application for a premises licence which lies before you today. Passingham Vineyard was founded in 2018 and covers 12 acres of land with some 20,000 vines, comprising of Solaris, Saval Blanc and Pinot Noir varieties. The vineyard is on land at the rear of Ripe, the grape transported to Halfpenny Green Winery, some 8 miles, converted into some 30,000 bottles of still red. Now, this is a modest operation as vineyards go. No products are currently stored on site. The site currently only grows the grapes, and all other associated operations take place off-site. The vineyard, despite its relatively short history, has received a medal from GB Wine Awards this year for their Nurton Brook White. It is therefore a quality operation. The registered address of the business is Passingham Vineyard, Greatmoor Cottages, Greatmoor Road, Passingham WV6 7AU. The physical vineyard address is Passingham Vineyard, Quarry Farm, Passingham WV6 7AT. The Passingham of 4 people have been Martin Wilcox, Jane Wilcox, Stevie Wilcox and Daniel Wilcox, who is not with us today. Stevie, who is here, works full-time on site, the others as and when needed. Stevie holds a personal licence and is the intended designated premises supervisor. The intention lying behind this application for a premises licence is to run a mostly internet-based pick, pack and dispatch operation from a small barn on site, providing a route to market which otherwise could only be available via third-party sales platforms. Any wine products brought on site going forwards will be stored in a secure storage unit within that same. They also intend to run a small-scale connoisseur vineyard experience tour. Twice a day between 11 and 7 at night on Fridays, Saturdays and Sundays between May and October. And these would have no more than 12 visitors per tour. All these places by the applicant would like to wine by the glass to these, to make off sales to them at the end of each tour. The applicant would like to conduct wine tasting events about once a month, ideally aimed at bulk purchasing clients such as golf clubs and restaurant chain owners, whereby such bulk purchasers would be invited on site to see the viniculture taking, and so appreciate the provenance and processes involved in producing this quality product. There is no cost to the ticket, as these are free events aimed at showcasing the vineyard and its products in the hope of gaining bulk orders. Lastly, the hours that the premises are shown as open to the public are from 9 o'clock in the morning until 5 o'clock at night. There is currently no gate to the premises, but the intention is to fit one and then only admit visitors by appointment only. There will therefore be no passing trade, nor a bottle shop open to the public on site. Now, as you can see, members of the committee, this application is, in my submission, de minimis by its very nature and is not capable of generating the sort of issues raised by the representatives. The initial application appeared on its face to be very broad in its terms and consequently attracted some concerns from local residents, which resulted in several representations which now sit before you. On the 26th, 27th of July, I wrote to the licensing authority, substantially amending the application to its current format to meet, I hope, all of the concerns that have been made in those representations. I asked the licensing authority to share that revised operating schedule with the attendant RAFD licensing conditions with the representatives. I had hoped that the representatives would engage with me, us, in negotiation, but we received no contact whatsoever. The original application must therefore be taking into consideration these substantial amendments of the 26th to the 27th of July. The application simply covers off sales by telephone and internet with a home delivery facility, and that is from 9 in the morning till 2100 hours at night. Okay, that's not it's every day of the week, but clearly you'd be operating those hours at peak demand, you know, Valentine's Day, Mother's Day, Christmas time. Okay. On and off sales on site via Connoisseur Vineyard Experience Tours, they would operate again, I've explained, between 11 and 7, 11 in the morning and 7 at night, on Fridays and Sundays during the months of May through to October annually. The hours open to the public being 9 until 5, Monday to Sunday, and a seasonal variation of opening hours, 9 until 7 on those Fridays, Saturdays and Sundays from May to October annually, referencing the Connoisseur Vineyard Experience Tours. Now, the business model for these Connoisseur Vineyard Experience Tours is this. There's going to be 2 per day. Each one lasts 2 hours in duration. As I've told you, booking is by appointment only. With tour parties of 6, you need about 6 to make it viable, but no more than 12 persons on any one tour. Okay. No parties will be arriving or be collected to or from the site via a public service vehicle, you know, a large passenger vehicle, coach tours, whatever that's written out. The wine tasting events are to comply with the Portman Group Guide to Product Sampling. The panel will also note that a revised licensing plan was submitted with my emails of the 26th, 27th, which have now been circulated to you. This shows a much reduced licensable area and consumption area as per these 2 little coloured dots on this aerial view. In this application, the burden is on the applicant to show that the proposals in the operating schedule are capable of promoting the licensing objectives and will not undermine them. Any representatives still opposing the application, on the other hand, following its amendment, have the burden to show that the premises trading under this amended operating schedule will undermine the licensing objectives and demonstrate that with evidence. In my submission, any subcommittee such as yours advised could only refuse this application if the operating schedule is found on the evidence of the representatives to be not capable of promoting the licensing objectives. Each application must be judged on its own facts and merits. Significantly, there is not a for you today that challenges or criticises in any way the actual offer as amended, the premises as described, the applicant being the partnership, or the designated premises supervisor being young Stevie. So, several representations have been received from neighbours in the village, to which I will respond to in detail shortly. But much more significantly, I will now demonstrate who has not made any representation and of their application. The licensing authority, acting as a responsible authority, here represented by Mr. Chisholm, and being responsible for the licensing in South Staffordshire. They make no representation against. The police, who are your primary source of information and evidence on all crime and disorder and ASB issues in South Staffordshire, we have come to terms with the offer of a CCT. They make no further representation. Environmental health, who lead on quality of life issues under the public nuisance objective. The planning department, themselves a responsible authority, deals with planning of permitted business uses of premises in South Staffordshire. Neither they nor did the highways department make any representation. Trading standards, who deal with underage sales of alcohol under the protection from children, protection from harm of children objective, and any other issues. They make no representation, and public deal with likewise have no issues with this application. It is a logical and compelling conclusion that all of the responsible authorities, by their silence, are satisfied that this application and its attendant operating schedule as it stands today is capable of promoting the licensing objectives. Otherwise, they would have made representations and would be here to argue vehemently against it. Further, it's clear that they, using all their expertise and knowledge of their the locality where the premises are situated, are satisfied that this application will not undermine any of the licensing objectives. Now, the representatives object on several grounds, including traffic, noise, and crime. Now, as you know, you can only consider those that relate to one or more of the those issues that relate to one or more of the licensing objectives. All decisions in licensing applications are made with the aim that all the licensing objectives are capable of being promoted, are not undermined, and so we'll turn to each in turn if we may. The prevention of crime and disorder. Licensing authorities such as yourself look to the police as the main source on crime and disorder and ASB issues concerns surrounding an application. The police have not made any representation, so it follows that they are satisfied that this application does not undermine the licensing objectives. The applicant does fit CCTV following discussion of the application with the police, which was the police's only concern. The theft of agricultural machinery referred to in some of the paperwork, though clearly unlawful and annoying and wrong, but it does not impact upon the desired licensable activities on this site. Public safety finds this as the safety of members of the public using the site rather than other concerns that are addressed by other legislation. The presence of agricultural machinery elsewhere on site does not offend the licensing objective, as this is clearly a working vineyard which connoisseurs will clearly enjoy visiting. Planning matters are not within the remit of the licensing committee. You will again note that the planning department has not raised an objection to this application, so it again follows that they are satisfied that nothing in the application undermines the licensing objectives. The applicant has addressed the concerns expressed about the volume of on-sales at the site by reducing them solely to take place during connoisseur vineyard experience tours in the summer months on Fridays, Saturdays and Sundays, which will allow for only very modest numbers of visitors to the site at any one time. The main licensable activity on the site will therefore be off sales via the internet with a home delivery service. I note the concerns regarding possible heavy vehicle volumes in the lane to and from the premises. This also has been fully addressed by the Connoisseur Vineyard Experience Tour format being adopted. This would involve the need to travel by public service vehicle or indeed any large or heavy vehicle. No representations have been raised by any responsible authority with regards to these issues in any event. I turn you now to, please, the prevention of public nuisance. Now, you will have noted that all requests for regulated entertainment, i.e. live and recorded music, have been removed from this application, expunged. The applicant has no intention to provide food to visitors, which is not a licensable activity in any event, and they have no intention to host any Glastonbury-style festivals, as this would most likely lead to the entire destruction of the vineyard. No representation has been raised by any responsible authority with regards to these issues in any event. And lastly, we have the protection of children from harm. Challenge 25 conditions, which are the hallmark of best practice, have been offered relating to this, and no other concerns have been raised under this objective. Consequently, this hearing is simply about whether these premises operating under this amended operating schedule will undermine or will promote objectives. Now, clearly my position is that it will promote them. It is a small-scale, quality operation which will not impact adversely on anyone. Consequently, I respectfully request that you grant this application for the premises licence as now sought, including the comprehensive raft of effective conditions, and in doing so, wish this modest but successful quality vineyard every continuing success going forwards. Thank you very much. Thank you.
There's no questions, so we can move to Mr. Evans. If you have any questions for Mr. Semper firstly. No, we'll move on to your submissions then, please.
Thank you. There are a great number of residents local to this application on its doorstep, the applicant premises on theirs, who feel for good reason that even the modified, reduced application presents an unacceptable risk of the prevention of public nuisance and public safety licensing objectives being unreasonably undermined. It is not safe evidence of responsible authorities that risks as they occur to local residents are in any way ill-founded or illusory. This is an application which proceeds in a particularly sensitive and quiet rural area. And it's very important, therefore, for the committee to see that as the starting point for the changes through that the applicant proposes. It's the starting point on the ground, and it's the starting point for any reasoned analysis of what the risk or risks that this application poses to the licensing objectives find. You will keep in mind, no doubt, your own policy, which recognises, as you know, that this is your area, rural area. Your vision, it is said, is to make South Staffordshire a safe and healthy place to live, with prosperous villages and thriving communities, where everyone can develop their ability to the full and pass on to future generations a better environment. It is that environment of Pattingham are principally concerned, as they say, should you be. Let me start with the prevention of public nuisance. Any consideration of a nuisance in a particular setting or context requires consideration of its setting. And the starting point here is that this is an application, the purpose of which is to introduce a commercial alcohol-led enterprise into the heart of this quiet hamlet. Really, as you've read from what the residents have, a very, very quiet and tranquil place to begin with. So that which reasonable people may be expected to put up with for the purposes of the legal test as to what is or isn't public nuisance, the answer is very little indeed. The residents have a reasonable concern that the creation as a reasonable group of people in the environment. At the moment, it's generally quiet as to noise, it's quiet as to vehicular traffic, and it's quiet as to other humans and the noise they might make generally, and if they were to be in drink. It's an area that's so quiet that other than the occasional car, you're more than a commercial vehicle, delivery van, and certainly not cars and other transport caused by other people's customers. As one of the representations stated, it's so quiet that even the noise of a contractor's radio carried to neighbouring properties. As another representation put it, a legitimate concern that these applications will shatter the peace of this small hamlet, and all the extra traffic will make it unsafe for residents and their children, given the narrow and poor local roadways. If you haven't been through Fattingham, you've got photographs that show just how narrow the lane is outside the applicant premises. That also introduces a second concern as to public safety on these narrow roads, which the residents say is entirely unsuited to any commercial traffic. Commercial traffic, whether it's a bigger van coming to deliver the wine so that it may be sold, or a big van taking it away, or a series of smaller vans and cars visiting for commercial purposes. And that is the extent of that problem is very difficult to gauge. But when you think about the activities that the applicant intends and the different reasons why people may be coming or going, particularly in respect of internet sales, which is really an open-ended concept here in terms of the potential for orders to be placed. No doubt there would be some system that allocated those orders to delivery vans who maybe, we don't know, maybe will be delivered by the applicant's own vehicles, maybe they will, perhaps it's easier to believe, delivered by third parties. But those third party delivery drivers would certainly have any great interest in the residents surrounding this property. We all know how drivers can behave. They want to get from A to B to C to D as possible and under some pressure. So that's the reality of the risk as the residents see it. The second point is that there are really two applications here. There's the original application, which has been superseded by the modified application. But the original application betrays, residents feel, will be the applicant's ultimate true intentions. The applicant originally sought the licensing of a vast area of open land, plus, as you read, live music, amplified. This, that past the current merits on the reduced or modified application, the fact is that even if that were to be granted on that limited basis, it will open the door to the use of the premises for further licensable activities in the future, inside or out, whatever the long-term plan as to entertainment may be. So the second point is that this isn't a situation where you're being asked to add to an existing licence. This is all about whether or not a licence should be granted in the first place. And the big change for the residents would be the difference between there being no licence, no extra noise, no extra disturbance, no extra public safety concerns, and having all three of those problems on their doorstep. The applicant may say, well, look, you've just got to look at the application before you, and we agree with that. But it doesn't detract from the fact that just granting a licence in the first place in this very sensitive area would, for the residents, be an enormous and unwanted step. The third point is this, that even on the reduced application, the hours and the permissions that are sought are unreasonable and too long. The application would permit off sales between 9 in the morning and 9 at night, every day of the year. On and off sales by the Vineyard Experience, 11 till 7 through the summer months, Fridays, Saturdays and Sundays. And those are the very times that this large group of local residents would want, in this very quiet, to be enjoying their quiet, peaceful local environment, whether that's in their own gardens or in the lanes around the hamlet. So when it's looked at from that perspective, this is a big change. There are long hours that are sought and a big set of permissions through the year. So, right to grant the licence, notwithstanding the legitimate concerns of the residents about the unreasonable undermining of these licensing objectives. Thirdly, the residents invite you to consider further trimming this application significantly to protect their opportunity to not suffer nuisance as a group of people in this quiet setting in and around their homes. There are other small concerns. Although you've been told something about the applicant's intention, I think you can see when the barn, the very premise, when it's currently full of agricultural equipment, it begs the obvious question that if it's going to be used for licensed activities and storage of alcohol, where's all that equipment going to go? Anything else important? So those are the amplified representations of those residents who, notwithstanding the problems with the blue notices, have instructed me to summarise their position and their ongoing. I hope that you, as a committee, given how many of them have attended today, can see that these aren't just worries and grumbles that people are prepared to set out on paper, but not back up with their presence. The fact that so many of them are here today and are so concerned about this application really speaks to the heart of their concerns, that the mere granting of any licence, even on this modified and more limited basis, will mean a big change to the residents of the hamlet of Pattingham.
Are there any questions from anybody on the committee for Mr. Evans? Mr. Semple, do you have any questions? Sorry, apologies.
It's a question, Mr. Evans. It's about I'm looking now at case law here. No, it's an article by Gareth Capener that appeared in the Grape Press, March 2014, and then it goes on to deal with case law. It's on page 76 of our documents, where a decision is reached by 3 very senior judges that ancillary agricultural activities, wine growing is considered as an ancillary agricultural activities which did not need planning permission. So, and they can export the grape from their vineyard to another location somewhere else and then bring it back in the form of wine back onto their farm. So they've actually got this freedom of movement already without us giving them any permission.
For the purposes of planning?
Yes, yes. Which I'm sort of reasonably comfortable with. What we're looking at is an ancient tradition whereby in this country we've made wine from grapes for a long, long time. And these activities in the countryside, in rural areas, have always legitimately taken place. And then from that, we've grown this new, diverse method of making money in the countryside by actually selling wine at the vineyards. We've got examples in South Staffordshire of that. And my question basically is, this is a very small activity that will cause some nuisance, but in life we all have to put up with the activities of other people and then balance. We have to then balance whether that is an acceptable intrusion into other people's lives or not, taking both parties into consideration. And my question is sort of 2 sessions a day throughout a period of time, that's 12 people visiting the site per day, is that reasonable or unreasonable activity?
That ultimately is, as you've said, a matter for your judgment. And you have to, as you've said, weigh up the public interest through the promotion of the licensing objectives.
Yes.
I agree with all of that. What's the worst case scenario for the residents on the application as it stands? A summer weekend where back to back there could be 2 tours. Maybe it could be presumed that not everybody will come in their own car. So you could have a maximum of say 18 or 20 vehicles overlapping, because you've got the people coming off the first tour. They're not just going to jump back in their cars. They're probably going to have that opportunity to buy that the applicant will give them. People turning up for the fall, they'll probably arrive a little bit early. So you're going to have a period of time with some substantial overlap. So that becomes, in its own way, busier than you might think. At the same time, there is the potential for orders to be placed and for orders to be being dropped off, collected on the off-sales business. Of course, what the applicant intends is for this to be a successful business. And successful businesses need customers and they have to be busy. But my point is, in answer to your question, when you think about it, even if it is, in the grand scheme of things, say as compared to a majestic wine warehouse, ever so much smaller, it's still something that can be busy and cause a significant disturbance in this setting. Whether or not licenses have been granted for other wineries and vineyards in different settings is another question, and they will have been determined on their own merits. But do any of them sit on a lane as quiet as this would be the question rhetorically posed back.
Okay. Doubtful, I suppose. I mean, I used the example that you've used, 18 to 20 vehicles per day, just for the tours, over 4 hours, 5 hours, something like that. Doesn't seem a lot to me.
a matter for your judgment.
Okay, thank you.
Are there any other questions from the committee for Mr Evans? Mr Semper, do you have any questions?
There is nothing I can't deal with in conclusion. However, yesterday, these only came into my possession yesterday. We've got supplementary photos of the area. That was very much a work in progress. I don't. Did you manage to get these? Receive these? These were emailed through to you yesterday. Were they placed before the? They weren't. That's a matter for you, Mr. Hodgkins, whether you wish to admit them. There's just the updated photos of the barns without the machinery.
What do you say the relevance is of the photographs?
The relevance is that there was some mention about some machinery left lying around and whether it be safe for members of the public to be there, to be wandering amongst these machineries in a licensable area. We've now got photographs of the licensable area and the secure storage where the wine will be kept. And there is an absence of that machinery there right now. I mean, will you take them as read, or it's a matter for use?
I think you can make those submissions in closing, but I'll turn to the chair to see what they'd like to do.
Yes, please.
Would you like to see them, ma'am?
Yes, please.
Okay, here we go. There we go.
Thank you very much.
Do you have a copy for Mr Evans?
I'm awfully sorry. It's comedy. Does any... Yes, thank you.
Does the committee have any questions for Mr Semper arising out of the photographs that have been submitted to you today?
No.
I think it's only fair, Mr Evans, I know you've only just been given this document. Do you have any immediate questions that arise out of it, or do you want time to consider it?
The photograph in the top left is that there is machinery behind behind some form of cordon. I take it then it's the intention for that machinery to stay even when the premises come to be used for licensable activities. Yeah. Oh, sorry.
Am I? Okay. Yep, the photograph that is taken shows a cordon with some machinery behind it. It is the intention that the barn is an agricultural barn, albeit it has a licensable area, and some small equipment will be kept behind there. Larger equipment will be kept at a barn, which I have on Greatmoor Road at Greatmoor Cottages.
Are there any further questions that arise? Anything arising out of that for the committee? No. If we turn to closing remarks, then perhaps start with Mr Semper.
Okay, I'm going to be really brief. Mr Evans pointed us to there being two applications here. The first one, the original app, he says betrays the applicant's true intention. With respect, no. The first application was made by Stevie, who's done her best and put in something that could be construed as being broad. However, the second application is what lies before you, and that portrays her full her intentions, the intention of the partnership. The second point, he said that the modified app, as granted, will open the doors to further activities going forward. Well, with respect, it won't. We do not intend to go further than the application in front of you. And in 5 years, if they did intend to go further, obviously we'd be back here applying for a variation. it makes a very, very good point about the possibility of back-to-back tours and cars coming to and from, meeting in the lane. And we take that point, and therefore we would like to offer that we have 2 tours a day, and there's some pretty, it's between 11 in the morning and 7 o'clock at night. So why don't we say that between the end of tour 1 and tour 2, there will be a 2-hour gap, and therefore those cars will never meet. Okay. So that's where we're up to. And you're absolutely right, sir. I absolutely take your point that the job of the committee is to balance whether this business in gaining its licence, whether it constitutes a totally unacceptable intrusion on the lives of local residents. So look, this application is simply about whether these premises operating under this operating schedule will undermine or whether it will promote the licensing objectives. Now, clearly, my position is not going to change. I believe it will promote them. A lot of thought's gone into the modified version as a result of the representations of these good people here. But you've got to come back to the fact that this is a small-scale quality operation which will not influence on anyone. We are not opening a Wetherspoons. We are not opening a bottle shop on site. This is primarily a niche. It's taken already 3.5 years to set up, and now they'd like to sell their own wine, please. Consequently, I respectfully request that you grant this application for the premises licence as sought in the second application, including the comprehensive raft of effective conditions and that 2-hour gap of condition that we just suggested. And in doing so, you wish this modest but successful vineyard every continuing success going forwards. Thank you very much. Thank you.
Mr. Evans.
Thank you. I'll be reasonably brief too. You have the points that I made earlier on everyone's behalf about how the residents feel that even the modified application is more than they as a group of reasonable people affected, which is the real question on the prevention of public nuisance. These photos, now that we better understand them, are surprising because I don't think I've ever seen a licence where there's potentially dangerous equipment and such a modest barrier to try and keep them apart. That does engage, in my submission, the prevention of public safety licensing objective. People are curious. People who've had a few glasses of wine might be particularly curious or silly, and there's clear potential for someone to cross that barrier and be silly on or with that equipment, unless absolutely closely supervised. But that looks, we would say, to be an inadequate barrier on that point. Even with the concession that's been offered as to the tours, of course, the consequence of having a longer gap is that the overall disturbance in terms of how long it is through the day is increased. So the residents, I think, on that point feel that wouldn't necessarily be any better for them. But the residents maintain their representations and objections to this application.
Thank you, Mr. Evans. We've come to the end. We've come to the end of the second part of this hearing. I can see the time is 5 to 1, so I'll see if the committee wish to deliberate now or have a lunch break and deliberate thereafter.
I've got another 2 o'clock appointment.
Okay, if we could ask that all parties leave the room while the committee deliberates, and they'll return with a decision in due course.